Good evening, everybody, and welcome to the Heartland Institute. Welcome to the Andrew Breitbart Freedom Center. Just wanted to give you a little bit of introduction of Heartland. Heartland is a 33-year-old national think tank who does things a little differently. We like to work with other think tanks, and we do most of our focus at the state level. So instead of focusing nationally, we focus at the state because we can get a lot more policy done that way. Over on the left is our distribution literature table. You will see newspapers, healthcare news, environment and climate news, budget and tax, and my favorite, school reform news. Those papers go out to legislators across the entire country. Every single week they're getting a new paper from us, and for 10 months out of every year. So when they're not in session, they're not getting a paper, but you can see what's going on. And my philosophy is if you don't fix education, you're not fixing any of the other issues regardless anyway. So the other center we have is on constitution reform. We do not have a newspaper for that, but there is information over there. All that literature on that table is free. Please feel free to pick it up and take it with you. On the back table actually is one of our newest publications, actually two of them. Lindsay will talk about one of them, but our education choice poster is back there. Feel free to pick up a copy. If you had no school board members or teachers or other people that are interested in school choice, please take them a copy so they can post it on their wall, post it on your wall, get people in different businesses, start the discussion, because that's the only way we're going to get anything changed on anything is getting a discussion going about everything. On my left also is the Michael Perry Mazur Library. It is probably the largest free market library in the Midwest. We are now approaching 18,000 books now. So we're always looking for donations of more books. We're always adding to it. I know there's a bunch of books we have to go through now to get added in. One of our library volunteers is actually at the event tonight. So, but our library is open. When we're open, our library is open. If you want to come in and read some of our books, look at some of the stuff we have, there's a list on our website. You can go to heartland.org/library and actually click a link there, and you can go through and look every volume up and see what books we have. You can look that. If we don't have a volume that you want, let us know, or if you have a copy, you can donate that copy, so make sure it's there. So, also on my left here, there's $1 per book. Sometimes we get a lot of extra books in, and we will actually put them up for sale for $1. So any of the books on that shelf, you can take for $1 and read them. And so you're welcome to look at that and pay at the back table on that as well. So right now, I would like to introduce Lindsay Stroud. She's our government relations coordinator, and she's going to come up and tell you a little bit about what our government relations department does.
Well, hello, everybody. I'm Lindsay Stroud, government relations coordinator, and I'm part of the government relations team. And I know you're probably wondering what government relations does, as we're a think tank, so it's all government relations, but we have a few roles that we do specifically. One of the things that we do is we coordinate experts that provide testimony in legislative committees across the country in all 50 states. This year we've done 12, 2 of which were on education savings accounts in 2 different states. We also host educational events for state legislators, including our emerging issues forums. These are conference, like events that we have panels on all of our topic areas and experts, and we do them a couple times a year, and we also have really good turnout for that. We also provide on-demand research on the pending legislation in states related to our issue areas. You guys should already know them, but I can go over them if you'd like me to. And one of the things that we've done recently, and as you already said, it was our education savings account policy brief that my policy analyst Timothy Benson just published yesterday, went online. As far as what government relations has done on education this year, as far as all the research we've done, rolling back Blaine amendments, we've repealed and replaced Common Core and expand school choice. What I do here is a little bit of everything. I do some providing the research with the research and commentaries and op-eds. I've also published a policy brief that you can find on that table over there on vaping. It's one of the issue areas I've covered as well as constitutional reform. Right now I'm in the middle of databasing and getting information on state legislators, which is really important to get all of our publications out to them. As you know, many state legislators have full-time jobs. They are not in session all year long. So if you send stuff to their state house, there's a good chance they're not going to get it. I know. I've worked at a couple state houses in Virginia and in Minnesota, and I know my guy didn't get a lot of his stuff. So it's tedious, but it's important. If you guys want cell phone numbers, I could probably find them for you at some point. You know, random state legislator in New Mexico, I know, as I was doing today. So if you have any questions about what GR, government relations, does, feel free to let me know at the end.
Now I'd like to introduce our speaker for the night. I know some of you and what's been happening. School mom. She also has. She helps her husband schooling her children, and in her spare time, she actually coordinated the National Christian Forensics and Communications Association Illinois qualifier this year. So every kid that was coming through the speech and debate clubs, she helped run that tournament. And her kids were also participants as well. So she keeps very, very busy. So I'd like to introduce Heidi Holen.
Thank you, everyone, for being here tonight, and thank you to Heartland Institute for allowing me to handheld mic. Justina Pelletier was a young teenage girl living in Connecticut with her family who had been diagnosed with a rare hereditary condition known as mitochondrial disease. Now, as long as she kept up a proper diet, took her cellular supplements, and saw her regular doctors on a regular basis, she had a primary care physician who had diagnosed the disease and a team of specialists that work with him at Tufts Medical Center in Boston. As long as she took care of some things, she was able to do all the normal activities that children her age were able to do, including one of her favorites, which was ice skating. However, in early 2013, she began to have some flu-like symptoms. So they contacted her primary care physician, who told her, the regular GI specialist you see, and who she had a relationship, has relocated to Boston Children's Hospital, so you really should go there to see him. At which time her parents and her made the 3-hour journey up to Children's Hospital, and on arrival began one of the most horrific chapters of their lives. The hospital refused Justina, they refused to allow Justina to see her GI specialist. Not only that, but the doctor who diagnosed her claimed that she had a psychiatric condition, that these medical conditions she was experiencing were all in her head. So her parents, who had been dealing with this for a while now, pleaded with the hospital to transfer her over to the other side of Boston to Tufts Medical Center, where her regular doctors were. Instead, they called Massachusetts' version of the Child Protective Services, who came in, accused the parents of medical abuse, and took custody of Justina. They placed her in the psychiatric ward of the hospital. They refused her any treatment for the mitochondrial disease. They refused to allow her to see her parents, except for 1 hour each week under supervised conditions. This went on for 14 months, at which time there was a little bit of a scandal within the CPS of that state. Someone resigned, and the spotlight from media began to shine on some of the cases. Justina was one of it. If you've heard of this, you probably are recognizing it. 2 months later, the state of Massachusetts finally returned custody of Justina back to her parents, and 16 months after she left her home, she was allowed to go back into it. Now, if I can get this feature to work right, I will show you a picture. I'm pressing the right button here. 2 months before she went to the Children's Hospital, she was ice skating. The second picture was taken 9 months under the care of the state. You can see her health has deteriorated tremendously. She is still in a wheelchair to this day. So, when it was ratified, our state constitution did not list our individual rights in it. Those inalienable rights given to us by our Creator were assumed by most to be self-evident. However, I think most of you would agree that you were grateful they did pass the Bill of Rights and state specifically within the Constitution, enumerate the rights such as freedom of speech, freedom of religion, freedom to associate, as well as they put in the 9th Amendment, which makes it clear that our rights are not limited to those enumerated within the Constitution. Now, our topic tonight, parental rights, is not one of those enumerated rights. However, neither is a student's rights to have taxpayers pay for their college education. But I would guess that most of you think one is an inalienable right and one is not. Now, over the years, our justice system has been very active determining what rights citizens have and how those rights should be protected. So, for example, the Supreme Court has determined that parental rights are a fundamental right, and therefore they deserve a standard called strict scrutiny. So if a case is to come before, if a law potentially violates that parental rights, the burden is upon the government to prove it has an interest of the highest order and not otherwise served before it can infringe on that right. And if it infringes, it must do so with the least restrictive means. So that's known as a strict scrutiny test. It's also a compelling interest. All of the rights enumerated within the Constitution are given this fundamental right status, the highest level of protection. They've also made some of the rights included through the liberty interests of the 14th Amendment. Some of those rights have been given fundamental status, so they have the highest protection. Now, other cases that come before the courts, the other basis used is usually a rational basis standard, so if the government has a rational reason for infringing on someone's rights, they can do so. So what has the history been for parental rights? One of the earliest liberty interest cases that came before the courts was in 1923, a case called Meyer, which made it clear that under the liberty interest of the 14th Amendment, an individual had the right to establish a home and bring up children. So it was a rock-solid decision right there in that particular case. And 2 years later, one of the most famous cases, and I even was talking to someone today who was familiar with this case, Pierce versus Society of Sisters, in a decision given in 1925. As a home educating parent, this is one I was familiar with, not just because it solidified, but it also was regarding education. It occurred in 1922. There was a referendum on the ballot that was changing the compulsory attendance law. Usually a compulsory attendance law will simply define the age that the children has to attend education, but this one went on to state that the child must attend a public school and do so within the district in which they live. So needless to say, the Society of Sisters, a non-public school, it ran some religious private schools, as well as Hills Military Academy, a noted military academy out of Portland, Oregon at the time. They sued, took it to court, and it made it to the Supreme Court, and the decision was released in 1925 unanimously in favor of protecting the fundamental right of parents. Now, the second clause I've highlighted, the child is not the mere creature of the state, is something that you will also hear. So some of the phrases that come through these courts that develop over the year have meaning within the court system, and it's important to remember the phrases and the meaning that the court attributes to them. So from 1925 on, there were quite a few cases that continued to defend the right of parents. And there was another one in 1978 that had a phrase that you will hear frequently also. And it stated that it recognized natural bonds of affection lead parents to act in the best interest of their children. So a pretty solid foundation all the way up until the year 2000. At which time a case came before the courts, again out of a West Coast state, this time out of Washington, known as the Troxel decision. It had to do with a visitation statute. Most people will recognize the term a grandparent's visitation statute. Now, this particular statute didn't limit the petitioning of the court for visitation rights to grandparents. It was very broad. It allowed anyone to petition the court to visit a child against a parent's wishes, even if harm was not proved. So it was a very broad statute, not surprising that it went up to the Supreme Court. But what happened at the Supreme Court is what has caused confusion to parental rights. It was a plurality decision. There were 6 opinions were written, 3 in the majority, and 3 dissenting. And regarding the plurality decision, which was signed by 4 justices, they did make it clear that parental rights is perhaps one of the oldest of the fundamental liberty interests. Terrific. We're off to a good start. The problem was, although the statute was struck down, it wasn't based on a strict scrutiny standard for protecting parental rights. There was a lot going on amongst there, but that wasn't the standard that was used. And in fact, if you see this last clause, this is one of the ones that has caused the problem. They determined that if parental rights was going to be the issue, they said if a parent's decision of the kind at issue here becomes subject to judicial review, in other words, they're leaving the door open for it to come up again, the court must accord at least some special weight to the parent's own determination. Special weight is not the same thing as a fundamental right and strict scrutiny. And that is what has opened the door in the lower court system, so that now you will see justices that don't know which standard to apply or can pick and choose. Now on the plus side, on Justice Thomas's decision, he did state that all of you said this was a fundamental right, and we probably should have applied strict scrutiny. But the way the case was argued also came into play here. But they all admit, for the most part, that it was a fundamental right, except for Justice Scalia. And Justice Scalia said why he supports parental rights, and he even wants the state to have no power to interfere with parents' authority over the rearing of their children. He stated that in this particular situation, the Constitution didn't give him the right to rule on something that was an unenumerated right. So I put that phrase in highlight, it's the unenumerated rights. So that's what has caused the confusion in the lower courts. Which standard of protection should we give? So you think back to the medical decision with Justina. You had two physicians, both of them giving a different diagnosis. Who should have the authority to make that medical decision? That's what's at stake here, and we shouldn't have confusion in that issue. Now, normally at this time I would bring up one other issue, and that is the United Nations Convention on the Rights of the Child. That is a treaty that during the Clinton administration, he sent it to our ambassador, he had her sign it, and it was Hillary Clinton's ambition to get the Senate to ratify that particular treaty. She didn't have enough votes in the Senate. It laid dormant during the Bush administration, and then when the Obama administration came in, the President said that he wanted this treaty ratified, and Senator Barbara Boxer stepped up to push this down the road. Now, by best accounts, she wasn't able to get a vote on it because it appeared she was going to fall about 7 votes short of it. But it's, and under the current administration, we don't fear that it's going to be passed. But here's what I want you to remember about this particular treaty, if you remember nothing else. That phrase that I showed you earlier about the best interest of the child, that is continuously used throughout that treaty. But the problem is if you read all the way through it, it gives the authority to determine the best interest of the child, not to the parent, but to the United Nations Committee made up of 18 people from foreign countries. So things get a little bit technical and you have to be careful. So just think about that one. That's in the background for now, but obviously it won't go away since we have signed on and it can go through the Senate at any time. So parentalrights.org is an organization that was formed back in 2007 by a group of people that had started to discover, one of them being the legal organization that represented the group that when I was homeschooling. So I was aware of it, but I didn't know all of these things that were going on, where they were meeting and discovering some of these cases that were coming as a result of the Troxel decision especially. And they determined that one of the best things they needed to do was to write an amendment to the U.S. Constitution and have it enumerated directly within the Constitution that parental rights are a fundamental right and deserving of the highest protection under the law. So that is what they did. They had an amendment. They wrote it. We've introduced it in 5 of the last Congresses. We have not done so yet this year, but we have had 10 states that have passed a statute saying that parents' rights are a fundamental right and deserving of the highest protection. We've actually had 6 states pass resolutions asking Congress to pass the Parental Rights Amendment and send it to them for ratification. So it's a grassroots movement, which most people nowadays are very familiar with, being very active, and since you're here tonight, I'm going to assume that some of you are just the same. So that's where it stands. Now, on your tables, you have some information about parentalrights.org, but you also have a sign-up sheet. And if you sign up to receive our email, you will be able to track what's going on with the amendment at the congressional level and also at the state levels. And we've been doing something which I like the last couple years, is we have a newsletter which has been highlighting some of these cases, such as Justina's and others. And we've focused on putting them in 4 different categories. First, well, not first, but medical settings, similar to Justina's, who makes medical decisions for the child. Also education, obviously, and not just homeschooling, but also in the public schools. For example, what if a parent has a situation where they don't want their child to read a particular book that's been assigned to them? What if they want to visit at certain hours? What if they need to pull the child? There have been a lot of conflicts in those areas. So we have the education category. We also have child protective services. So yes, there's some crossover with that and some of the other areas, but then there are some clear-cut cases. So I'm going to come back to child protective services, and then we have, the last one has been a very interesting one, and it was one that I wasn't quite expecting until I heard about it, and that's parents with disabilities. Now, one of the interesting things about parents with disabilities is there is a precedent in the Supreme Court that has allowed 10 states to have statutes on the books to this day, which says the parental rights can be terminated for parents solely because they have a disability. There are 35 states that say they can use the fact that a parent is disabled in weight to determine whether parental rights should be terminated. Now, they understand what's going on in this case. In 2010, there was a case I heard about, and it wasn't even associated with parental rights when I heard it, or I didn't come from them. Two parents went to a hospital. The wife gave birth to their child. They went to leave a few days later, and they were met by the Child Protective Services, who took their child into custody because both parents were blind. It took 57 days for them to get that child back. And again, they had limited visitation. Now, you have a newborn and you're a mother, you know what that does. So, why are these things occurring? We do not have a priority on protecting our parental rights. Now, Child Protective Services, obviously no one supports a situation where a child is going to be abused or neglected. But we also see some situations there. And to do this, I actually have a video, if you want to cue up the video. Latasha is actually local, and she has dealt, oh, do I need to turn off? Okay, I'll let him deal with that. She deals with DCFS here in Illinois. She has dealt with them personal, and she's going to tell her story, and she's going to tell what she has seen within her community. So this is Latasha's story. I think I talked too fast and he wasn't expecting this soon. Sorry. I see your face.
I just want to briefly share with you all my experience dealing with DCFS. The decision to start the process of being foster parent was personal. Because the young lady, she was 15 years old at the time, she was already a big part of our lives. We had already been somewhat involved in her life 2 years prior to the incident that caused her to be a ward of the state. And so as the process began to progress, and as the caseworker became more acquainted with our family, that's when I seen that her temperament towards us was changing. In other words, that's when my husband and I both, we gradually started seeing the bias, or how she was just not as favorable to what we stood for as Christians, which eventually transcended into us being homeschool parents. However, the child even began to understand the caseworker's disposition, and it was just really causing her more stress, more psychological abuse. It just added to it, and especially the fear of her possibly being removed out the home. Intensity I began to feel concerning my parental rights, my husband and I, our parental rights as parents, because what we would communicate to them thoroughly was that if you don't see our faith being the best thing for her, or if you don't see the homeschooling being the best thing for her. And then quite naturally as parents, we're feeling like you're looking at our children and now our parental rights concerning our faith and our educational plan, our educational desire for our children, it seems to be kind of threatened at that time. And so we felt it was in our best interest that we exit or withdraw from the program before things really heated up. In the Black community, unfortunately, this bias is familiar, and it's very grievous to us that we see this pattern of disconnect, of disrespect, of racial disproportion and disparity in the Black community concerning their parental rights. And again, mainly from the caseworkers, we see where their personal bias is really interjected into the handling of these cases. And so that's why we see the African American children are represented, at a 1.8 times higher rate than the general population. And that's why we see that they are victimized higher, because it seems to be, a racial bias to rip apart our families. And so many of us, people that I speak to a lot, they want to foster. They're willing to foster. They're willing to bring children into safe and loving and stable environments, but it just don't seem as welcoming being a Christian. And now to add to that, you're a homeschooler. So again, I just believe the bias in most cases is very subtle. And so what it does, it cripples the family with fear because they don't want to be the target of the next investigation. And so they're very reluctant to foster these children. And so overall, the system is just overreaching. The caseworkers, again, are just interjecting their own personal biases to the process. And so at the end of the day, it's almost that these children are being abused within the system, within the walls of the system.
Okay, and she actually did a 14-minute speech for me, and I'm sorry I had to edit it down. She had a lot of information that she provided, but she's living this day in and day out. And I first met her when she contacted me. She had just heard about the Parental Rights Amendment, and she called me immediately and said, I want to be on board. I want to help. What can I do? Because she is living this day in and day out. She's seeing, like she was talking about the bias, and we have some studies on that. I don't want to get too technical, and I think I want to watch my time to allow time for Q&A. It's real. We have the stats to prove that the bias, and again, it may be the caseworkers, but this parental rights protection needs to be at a level where people recognize, first and foremost, they need to acknowledge them, respect them, and truly look at the cases that have the abuse and neglect before they remove the child from the home. So no one's denying that that needs to occur. Now the other thing I need to tell you, one thing about Latasha, she's become so passionate about this, and I've been the state coordinator for quite a few years, to be leading our states into the next things that we do with this as well. Up for his email. Questions that you have.
Like always, raise your... With that, the vendor have been charging for like this for free. So, and I want to thank Heidi again for coming up. So if anybody's got questions, please raise your hand. Let's give Heidi a round of applause real quick too. You're getting...
Number 6 refers to the fact that if you're a parent, your child's doctor must have your approval before giving your child a vaccination, and of course that's false. So my question is this: will this amendment address that, and will it also address the issue where children will not be allowed in school unless they're vaccinated?
Great question.
Let me address the first part of your question first, where you asked if it's going to address the vaccination issue. Keep in mind what the Parental Rights Amendment is going to do. It's strictly going to apply strict scrutiny to these state statutes. Now, regarding vaccinations, whether you choose to vaccinate or not vaccinate, Parental Rights does not have a position on that. That's not the issue. We simply believe that that decision should be a medical decision made by the parent, so that we would say that those type of statutes are not lawful. They're unconstitutional. That would be our determination on that particular situation. So that kind of answers your second question also. But they would have to be tried on a case-by-case basis because that's becoming more prominent. What states are doing at this time right now is they are removing the philosophical and religious exemptions right now from statutes from vaccinations. So people they're not able to opt out of them anymore. And we believe parents have some serious concerns about them.
Make sure you keep your hands up so we can know where the next question's coming from and stuff as well, too. So the next person can come and bring you the microphone, because you're also being videotaped on camera, so your question is going out live as well. So everybody in the audience that's watching online can also hear your questions and hear the responses and stuff as well. So over here, Veronica.
Okay. Now, is this a constitutional amendment to the U.S. Constitution or the state of Illinois Constitution?
Right now, we have it at congressional level. We want this to be a federal statute.
Okay.
I'm sorry. We want it to be at the federal level. We do not want a statute. We do not want Congress in charge of this. We want it to be enumerated within the Constitution.
Okay. How do you keep the Constitutional Convention on this topic only?
This is an amendment that would have to be passed through Congress and then sent to the states for ratification. It's happened many times, well, 27 times,
Right.
10 at once and then 17 times after that.
So yeah, Heidi's talking about the traditional way of Congress passing it and then it's sending it back to the states, not
Yes.
the Article 5.
No, we're not going through Article 5. We have the amendment. We've actually had it in Congress the last year.
Text of the amendment?
Yes, it's on one of the pieces of paper. In fact, I have it. Oh, we pulled the screen up. I did have along, but it was very small on the screen.
Yeah.
So one of the interesting things is by working with these other organizations, I mentioned the parents with disabilities. When I first volunteered with this organization, we had 3 sections to the amendment. But since working with these groups, especially with the disabled group, we added a line for them because of the precedent they have and that they face. So that was one of the things I think was a good addition. So.
Okay, next question will be right here.
Yeah, Jim McDonald. The first example you had of the 13-year-old ice skater, the problem between the hospitals, I'm just sitting there wondering, was there something the parents should have done or could have done more direct? I mean, they had a doctor. Why was their doctor overruled by another? Was it politics or?
Just on in my opinion, a minor situation, they went through the emergency room because they were transported there in a hospital because of her condition at the time. And it was because she went through an emergency room that played into the standard procedure of the hospital, where she didn't get access to her GI specialist. But from there, at this time, the parents basically did everything they thought they could. Literally, Tufts Medical, they had the diagnosis from them. It was simply two different diagnoses. But when they called in the state, and the state says medical abuse, they immediately can take custody of the child because they believe they're removing them from an unsafe environment for that child.
I mean, this is the kind of fear that every parent has.
That's what.
And, you know, you wonder why somebody gets radical when the government steps in and you got 2 legitimate doctors, both certified, and the government decides to side with one and you have no option.
Technically, they would say they believe they were protecting the child. So the question is, this gets into something which is again going to go back to the state level. Both of you have mentioned federal versus state. Abuse and neglect can vary state to state and how they define it and how they apply it. And I have to say, one of the organizations, because we hear about these cases on a regular basis, and we actually have started a foundation to start to help people. It's a fledgling effort at this point. But we refer some of these people to attorneys that they can work with. And we have a terrific one here in the state of Illinois that we refer to, where she is truly working on the Illinois statute of definition of abuse and neglect. Again, we don't want what happened in Joliet to ever happen again. But
Well, I track that fairly regularly on the internet, but it kind of dropped off. Have there been any charges brought against the hospital and the organization that kidnapped the daughter?
For Justina?
Yeah.
Yes, they brought charges last year.
Thank you.
Yes.
Okay, but right before the next question, on your table is the actual Parental Rights Amendment. It's the solid white one there. So if you haven't found it yet, it's there for you to read. It's also on their website as well, too. So in the back.
Yeah, two somewhat related questions. The first with this poor Justine case. Am I to understand that the same Harvard Medical School, let's not kid ourselves, this was Harvard Medical School trumping, if you will, Tufts Medical School. And in I actually remember the case quite well and looked into it quite a bit at the time. And there were professional jealousies. There's all kinds of really dirty, expletive deleted going on there. Poor child. But the irony is that these same doctors, no doubt in my mind, had Justina appeared in the emergency room in Boston requesting an abortion, they wouldn't have even notified her parents. She would have gotten it. No questions asked. And I guess they couldn't quite give her a medal for it, but they would have treated her with great respect. Now, that plays into another related question, which is, I don't think anyone would want to give 4, 5, 6-year-olds much control over their own lives. So that would, even the stupidest leftist can see that that's wrong. But what is the right age? I mean, 18 seems to be the sort of default age where you can do pretty much anything you please that isn't barred by law to all citizens. 17, 16, I mean, we've seen 16 to 17-year-old teenagers, both boys and girls, being convicted of statutory rape by virtue of relations with other 16 and 17-year-olds of whichever sex. It's bizarre. I mean, I'm not going to take a moral view of it or anything like that, but that's just stupid. And so to what extent should the state determine the various ages at which children's own views should come into view? I say that for the Justine's case because she was 13. She wasn't a baby. Okay. She was a beautiful young lady. And by everything I read about her, perfectly capable of making decisions about herself and her own life, dare I say her own body. And yet she was denied any say at all in this. Not only her parents, but she was denied that in favor of a bunch of strangers who really didn't give a crap about her personally. I'm sorry, the end of rant. I apologize.
I can't answer directly how much weight a child should give you, but except for the fact you need to remember that who has the legal authority for minor children. And that's really what it's going to come down to. There are some situations where sometimes they look at the constitutional rights of the child. And for example, that abuse and neglect would be one of them. So that will come into play. But in this case, you do have to honor the fact that a minor child.
A statement or something from experience that I just happen to know. I have a growing daughter. She's now 9, and she resides with me. But one day, who knows when, she's possibly going to want to reside with her father. And when we went through the court process to actually do the parentage and the visitation by law, I was told by a judge, actually, that by the time my daughter is 12 years old, she can decide who she lives with. I say, damn that. Because at 12 years old, as competent as my girl is, I am absolutely certain that she should not be the decider of where she resides. Mm-hmm. Is that my right?
One of the situations with divorce courts is that they are going to be determining the best interest of the child simply because of the nature of it.
If I carry a child, who else determines the best interest of the child?
Right.
It's beyond bizarre.
It's very complicated. It gets very complicated.
So the question here with Jim, then we're going to come to you in the center, and then back over there to Michael. So,
yeah, Jim Bedell. I'm a clinical psychologist, and I've got a real interest in shared parenting. I'm an advocate of that as long as the parents are fit. That's a determination. So how does the interface between this amendment and, you know, the argument of two people who have children and are looking for custody? You know, there is the argument that they have a constitutional right to equal access to their children.
Again, in divorce situation, especially in custody situations, it's very, very complicated. And it does have to go to the courts. It really does, because they both have the same constitutional right to some extent.
But I mean, with this amendment,
it's
somewhat
not going to make a difference when it is the court needs to determine between the two parents.
Why do they
especially.
determine? If the assumption is that they have an equal right to access to that child for parenting.
All we're doing is taking the right and putting it in there. We're not making the decision on a case-by-case basis. That is what the courts do need to do.
But would that influence the states to have to follow a constitutional argument that parents
Yeah, it
have
would.
an
That's-
equal right to access to their children in a shared way?
I think both sides in the situation would be able to argue that they have the constitutional right to make decisions for their children, of course. But that's what it's giving them. But by being in court with the split of the parenting rights, the court has to make a decision.
I'm going to piggyback one more time. I have a lot of experience in a lot of this. So maybe a year and a half ago, Heidi, you may have heard of this, and other people in the room may have heard of this. They completely killed the word custody in the state of Illinois. They say that the word custody brought along negative tension within families and literally eventually broke up families. So it's interesting that you use the term shared parenting, because now that's the term that they're using in the court of law. And what shared parenting implies is a dad gets 20% of the children's time to choose sports that they play, but the mother chooses religion. I think that's crazy. And I don't know if you can realistically raise little people that way. And so most people go through the motions and then they just raise their darn kids, because it's almost not even conceivable to say 15% of this belongs to dad and 12% of this belongs to me. But it is literally that tedious. And in divorce court and in figuring out parenting among divorced parents, it literally becomes a conversation of how much percentage do I own our child.
Well, shared parenting technically is 50% of actual physical custody of the child for one parent and 50% for the other parent. And the distributions of responsibility for decisions don't really come in that much in shared parenting decisions. I mean, really, the theory is that the child can adapt to the specific, parenting environment of one parent, and then can adapt to the parenting environment of the other parent. And they may be different, because children have rights to parents. And the old argument is children, and yet that's what the state.
Hi, my name is Kara. I'm a high school teacher in a public school, as well as a parent of a disabled young adult. She's 20. Had the extreme. I've been threatened. Her father's deceased. This was just teachers calling and peers of mine, which was it's just unbelievable. And but I was fortunate enough to run into an attorney's group. So now I'm basically covered. But I had to, in order to maintain my daughter, who functions more like an 8-year-old, I had to give up. The state of Illinois requires that you give up your custody to the state in order to maintain your disabled rights. So essentially, I have a probate judge for my daughter who makes all decisions for her that I have to check in once a year with her through Cook County. I am her guardian, but this is the only way that I can have say-so. But they can take her away at any moment, and any parent of any disabled child has to do this in order to make any medical decisions for their child.
But just let me ask you a question. Do you believe that's right and just in the way the law should function?
No, but there's no
That's
other
my
way
point.
around it. And is there
Right.
anybody who's advocating a different way around this system? Because, and I know my attorneys are saying, and they're doing the best that they can.
Exactly.
They're amazing. And every 5 years, we keep a special needs trust open, and all of us parents of special needs young adults, we have to keep special needs trust open that we have to open every 5 years to make sure that the state of Illinois cannot attack their money. So, and we have to pay to have that redone. But I'm saying, is there anything that anybody that's working to change the laws so that we can maintain custody without giving up custody to the state?
There are
Essentially,
people
the
out
judge
there doing
is in
that,
charge
yes.
of. There's a probate judge that isn't. They could come into my house any day and take my daughter from me, and I would have no right because I had to give her up and take away her rights in order to keep her.
But I would have to say there's probably quite a few statutes or policies that are being violated if you were looking at it from the angle that parents have the authority to make the decision for the children. So we would have to look at all the laws that are tied into that force that to happen. That's the problem. I realize that. And I'm not saying it's right. I don't believe it is right. And that's one of the reasons we need to put it at the forefront, that your rights need to be protected first and foremost. In my opinion, there's no reason for that. If they haven't proved abuse or neglect, why do they have custody of your child?
Real quick, before we go to Michael, Heidi, can you tell people how to find out more about parental rights and other resources that they may need to be able to find?
Certainly. As the title tells you, parentalrights.org is where you can find a lot of resources. You can sign up to join our efforts and get our regular emails there also. But they have a resource section. There are videos. There are papers. You can contact them if you want to just get in touch with our central office. Actually, I'll get your contact information afterwards. But you can contact people through the old-fashioned phone. If you wanted to reach someone in Virginia also, they always have someone on staff. But the best way is through the website and check out some of our resources there. I just printed out a few things, but there's quite a few more on the online. So.
Okay, Michael? Oh.
I wanted to ask you what your thought was on this. With as far as she was just discussing and probate, how they have custody of her child or legally, and a lot of, there's other situations where not just probate court, but family court and others, where you have GALs, guardian ad litems, that come into play. In family court, they have child representatives, attorney for the child, all these other, where they come in and they're court appointed. They're appointed by the judges even against the parents' desire. And they're forced, the parents are forced to pay these other attorneys. It's a pay for play. It's all corruption. Yep. And it's all corruption across the board. So it's a pay for play for, draining the children's college funds. The parents, you go into, for example, a divorce situation, and the first thing all the attorneys say is, provide us your financial disclosures. Yep. Provide us the statements. They see what the assets are, and many times I've seen many families. I am a physician. I'm a pediatrician. I have seen this in many different. I'm an advocate. I'm an ADA advocate. I've had domestic violence training, anger management training. What I have seen is just so mind-boggling, and I just wanted to see what you had to say about that, because those are where the parental rights are taken away by these pay-for-play situations, where whoever has more money is directly paying the child representatives or the guardian ad litems. They're ruling in their favors. I've had court-appointed psychologists directly admit to me that they have been offered more money to alter the documents. I have seen this. The stuff is not directly put into the documents of what's actually being, so there's no accountability, no transparency. If there's no videotaping even of a lot of these interactions, what actually is brought before the judge is whatever they decide to. The children are gagged, the parents are gagged, the protective parents are gagged, the children are taken away. Sometimes they don't even have a chance to see their other parent again. And then you see, the disparity, what you're seeing is just, and then you're looking at, if they call in, sometimes they file false order protections, they come in, you have child, CPS come in, and CPS, for example, many of those, which you're fully aware of, he's fully aware of, he's an attorney, and sees a lot of these CPS individuals who are coming in they're not qualified whatsoever with no training. They're coming in and these children are being taken away. And that's how a lot of the children, the disabled children, and just all the fun. I mean, what I've seen is I don't even know how to even explain laws where there's not just false allegations being thrown about, just and hearsay evidence which is being brought forth. There needs to be accountability, I think, and transparency for judges, because a lot of the judges are truly they're appointing who they want so they can rule with a lot of little cash in the back, little,
Corruption.
You hear about all this.
I mean,
you
you can't really legislate away corruption.
Cook
think
County.
because that's
No,
by nature.
by transparency and accountability. of
Right.
all-
That's the point. Right. 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 Okay.
My name is Mick Gearhart. Dr. Bedell and Dr. Padron pretty much taken lots of things that I was going to say, because one of my concerns, I won't say concern, but one of the issues with the Parental Rights Amendment I see is what they're bringing up. We have divorces, it depends what community your rights. Since you already point out that everything they say is absolutely right, and I know we've discussed this before. Dr. Padron and Dr. Bedell, we've been to Springfield, we've testified before the judiciary committees, and I hate to say, they understand it, but once, special interest gets involved, I'll just say it right now, the bar associations get involved, every statute gets, destroyed, because it's what's in the best interest of the professional lawyers is what's going to decide what your statutes are going to be there.
And again, accountability and transparency helps with those items. Elections matter. We can only do so much, but again, just as when they put free speech into the Constitution, you still have lawsuits that have to determine you can't yell fire in a crowded theater. So you need the guidelines. Okay, we have the exception. The guidelines can be there. Is it going to ensure that people follow them? That's, I wish we could all be morally upright and honest. It just doesn't always happen. And
Diane?
unfortunately, children are hurt, as are
I'm
parents.
Diane Bast. I work for Heartland, and I'm just curious, who are the special interests? Who are the people lying against something like this? Who opposes it?
All right, does anybody else have a question? Oh, another one back up here. While the mic's being brought around, as you can see, parental rights touch almost everything. They touch you all the way from birth, childhood, even into adulthood, education, and custody. You fill out our survey if you'd like to donate, but also please stop by our literature table, see what's there, pick up what you want. If there's something we don't have, ask us for something. We are always looking for new things that we can create and papers to write. So thank you all for coming, and we will see you at our next event.